Mr. Norman, you're on probation for the third-degree felony offense of assault family violence by impeding breath or circulation. Looks like you were placed on that probation back in 2021, and that was a 4-year deferred probation. And I received an administrative hearing that shows it looks like you're behind in your court-assessed fees, and you failed to report as directed on June 6th. And the probation officer made some recommendations, and that was going to be for you to serve 15 days in the Jefferson County Jail, be placed on the high-medium caseload, some other things. And instead of doing that, I wanted to bring you here because obviously that any violation is not tolerated, but it looks like I wanted to know more if you only didn't report one time and you're behind in your fees. Are you working?
Yeah, I'm still working.
I'm sorry? Okay. Where you work?
Out in the steel.
Say it again?
Out in the steel.
Okay. Why didn't you report on June 6th? Do you remember?
June 6th, I was supposed to report. It was June 4th that I missed.
June 4th, right, because that's the hearing date.
Yeah.
So it wouldn't have been the day after. That's another reason why this was a little confusing.
Because what it was, I was supposed to say June 6th. They sent the letter. I thought that was for me to report for June 6th. And when I got in touch with her, she said I missed the administrative here. And I said, no, I'm supposed to see you June 6th. She said, no, it's for June 4th.
Okay. So why are you behind in your fees if you're working?
Well, I was helping my kids getting the car back up.
You were doing what? I'm
I
sorry.
was helping my children.
Okay.
But I'm in the process of getting the car back up now.
So here's the thing. If you have a job and you have the ability to pay, then you can do everything else right on your probation. And at the end of your probation, which is only 1 year away, you could still be revoked. You could be convicted of this offense, and you could still go to prison for not paying if I find that you could have paid and you didn't. So it looks like you've done most everything else, from what I can tell, very well. This is the first administrative hearing, but I do want you to understand it's very important that you get caught up on those fees. If you start making payments and you're not caught up by sometime next year, then what can happen is we extend it and you could be on probation longer. It's not meant to be a punishment. It's just meant for you to be able to finish paying, right?
So I was trying to be finished by August.
Well, then it sounds like you need to get to paying some money.
No, I mean, because I got it so far ahead to I could get paid off in August.
Okay, so here's what happens.
But I think I'm at 2200.
Yeah, so here's what happens. If you get all your money paid off ahead, it's not automatic that you get off your probation early. Okay, so a lot of people do get terminated off their probation early if they do everything satisfactorily. So I'm not saying that you're not going to, but obviously getting your fees caught up and paid in full makes it look a little better when you go to probation and say, hey, would you consider sending something over to the judge for me to get off early? But you have to be following all the rules, take care of everything that you're supposed to. Do you understand? Is there any other issues that I'm missing?
So I've spoken to his previous officer, and she said since the beginning of his probation, it's kind of been, we've been trying to get something out of him to want to be successful. Since the beginning, he's kind of already said his attorney had told him that he could get off in a third of his time if he just paid his money. He had another admin summons prior in 22, and it turned into a case staffing. He hadn't done any of his programs and conditions at that point. We had to pull it out of him to be able to do it. At this point, he's always kind of been nonchalant about probation. Even in his initial PSI, it even said that his nonchalant behavior could be a downfall for his probation. So this was kind of for us to see what you would like us kind of to do when it comes to that, since he's just been very nonchalant. It's when we enforce action or try and do a sanction is when he actually wants to do it. Because before I started making all the payments, he had told me, I'll get to it. It'll be done at some point. I promise it'll be done at some point.
So
very nonchalant.
Here's what we're going to do, Mr. Norman. It is not probation's job to try to force you to do what you got an excellent opportunity to be able to do instead of going to prison. It's not their job. You're not a child. They don't need to drag you along by your hand to do what you're supposed to do. And it sounds like you've done okay.
Alright, let's pause right here because this opening statement from the judge is more important than it might sound at first. In probation cases, the court is not there to babysit someone's life choices. Probation is basically a second chance instead of prison, but here is the catch: if the defendant treats it casually, that second chance can disappear real fast. So the real question is Mr. Norman taking this opportunity seriously, or is he slowly walking himself straight back into prison?
Pay on probation, but it's only because they've threatened sanctions. So here's what we're going to do. There's no more them threatening any sanctions. You show up when you're supposed to show up. You pay what you're supposed to pay. Maybe you get off early. Maybe you don't. We'll see. But if you don't do what you're supposed to do, it's not going to be in another administrative hearing where they say, hey, we're going to ask for 15 days in jail, or, we're going to try to get your attention. Today's attention getting day. If you don't do what you're supposed to do, there's going to be a motion to revoke filed and you're going to end up in prison. It's just that simple. Do you understand? Do you have any questions about that? All right. Thank you. Morning, sir. Are you Ray Francis Jr.?
Yes, ma'am.
And Mr. Francis is charged with failure to comply with sex offender registration requirements. And Mr. Lewis, what's the announcement?
Well, Judge, I have gotten access to discovery and everything, but I do need a little time to get Mr. Francis in so we can go over it. I think by the next setting, we should be able to make an announcement.
Any issues?
No, Judge.
So, Mr. Francis, I'm going to reset your case about 30 days or so. Make sure you make an appointment to go visit with Mr. Lewis so y'all can go over all of the discovery that he's received, and we'll get an announcement at the next court date. All right, you're free to go. And Mr. Lewis, you have Zabaras Harrison, cause number 23 DCCR 1410. Good morning. I'm good. Are you Zabaras Harrison?
Yes, ma'am.
Why didn't you go for your PSI? I'm sorry?
I thought I was just waiting. I might have. I misunderstood that, I guess.
You misunderstood what? So let me ask you this. When you were here and you entered your plea of guilty, were you on bond or were you in jail that day?
I was in jail.
You were in jail, and so I let you out of jail that day, right?
You got me a bond. You lowered my bond.
Yeah, and I said some very specific things to you because I say them to every single person that I do that, right? Do you remember that?
Yes, ma'am.
Maybe I said that if you don't go to the probation department and take care of that pre-sentence report, that when you come back, you run the risk of me not accepting your plea agreement and things could be much worse. Do those words sound familiar?
I might have misunderstood you. I thought I was waiting to get back here to see what was.
Before you left that day, you sat in that jury box and the probation officer talked to you and handed you some papers and said, when you're released, come here. And they gave you the address and everything.
No, that didn't happen.
That did not happen.
No.
That would surprise me because that is what we do in every single case.
Yes, ma'am. It didn't happen.
So, but I told you to go to probation. I know I did because I'd never not say it. Never.
We signed for what I was going to give. And you told me that you wanted to do you wanted to take some more time with looking over things.
That I wanted to reset your case to get a pre-sentence report done. Okay. And that I told you have to go to probation. And I told you if you get arrested for anything.
Right. You told me you put me on the monitor and everything.
Yeah, I told you all that.
I didn't. I'm up.
If I test you today, you gonna have anything in your system?
No.
Have a seat. Let's double check that before I decide what to do.
No.
Pageant, you have Justin Living, 24 DCCR 0288. Good morning. Are you Justin Living?
Yes, ma'am.
And Mr. Living's charged with credit or debit card abuse. And what is the announcement?
Your Honor, I've received all the discovery on this case, and Mr. Living missed an appointment with me in May, and we have not been able to communicate since then. And my understanding is he also has a burglary rehabilitation case.
He was indicted 4 weeks ago, Your Honor.
So,
Okay.
I'm going with that.
Okay. So here's, do we have that? If it was indicted a month ago, we should have it. But here's what I'll do. Mr. Living, obviously you need to hire either Mr. Pageant or someone on that new case. And I'm going to just do a reset for
Well,
30.
Your Honor, I do have a concern about his bond situation.
I don't even have it.
and I'm not sure what it is either, to be honest with you.
I can tell the court, he made a $5,000 bond on March 24th of 2024.
Now this moment is critical. The judge shifts the focus to unpaid fees, and believe it or not, this can be a huge issue in probation cases. Legally speaking, if someone truly cannot pay, the court usually works with them, but if the judge believes the person could have paid but chose not to, that can actually become grounds for revoking probation entirely, and that is a scary position to be in when prison time is still hanging over your head.
In the state jail case, which is the fraudulent use or possession of a debit card, which is also enhanced to a third degree.
Okay.
About 2 weeks later is the offense date on this burglary, which he made a $20,000 bond on April 7th of 24.
You have the cause number?
24 DCCR 1100.
Oh, it's on the initial docket.
And that, Your Honor, he has one prior TDC felony, so that's enhanced to a first degree.
Are there, can I tell from this what conditions, where can I look to find the conditions? Hold on. Let me find it first.
And there is an arrest in the meantime for an assault family violence case, a felony, but that has been refused.
Okay. Where's the bond? What do you mean, go to the bond page? So it would be, here? Yes, ma'am. Okay. So it doesn't show any specific conditions. Let me look at the,
I can look in the jail screen and see.
double check if you see anything there while I look at this, something else. Pending?
My understanding is he may have 2 misdemeanors pending, Your Honor.
It's criminal adjustments and DWI. They're in.
Don't talk about this until she asks. And I'm not representing him on those 2 either. I wasn't.
Penalties on those.
Okay. Let me ask you this, Mr. Living. If I test you this morning, what's going to be in your system? Nothing? Let's double check that. Have a seat in the jury box, and then we'll might make at least some conditions, modifications on that bond.
Sounds good.
Mr. Wilkerson, you have Elijah Miller. Sentencing, cause number 23 DCCR 0402 and 0403. Good morning. Are you Elijah Miller?
Yes, ma'am.
Mr. Miller, you were previously here, entered a plea of guilty to the state jail felony offense of burglary of a building, and I've received a copy of your pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes.
I want to know that you're on probation in Orange.
Yes.
Have they filed a motion to revoke your probation because of this case?
No, they told me that because they happened like right at the same time that this would not affect it.
Your probation started after this. Okay. All right. Any corrections or objections to the pre-sentence report?
Nothing from the defense, Your Honor. Not from the state.
All right, Mr. Miller, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition, excuse me. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork, and I will sign a dismissal as part of this plea agreement in clause number 23 DCCR 0402. All right, good luck to you, sir.
Thank you.
Mr. West, on Leonard Guillory, sentencing in clause number 22-40982. All right, sir, you Leonard Guillory?
Yes, ma'am.
And Mr. Guillory was previously in court, entered a plea of guilty to unlawful possession of a firearm by a felon. I received a
All right, this is the moment where the tone of the courtroom changes completely. The probation officer just revealed that Mr. Norman has been pretty nonchalant about probation from the start. That is a dangerous attitude in court. Judges pay very close attention to effort and accountability. When someone only complies after being threatened with sanctions, it sends a clear message to the judge, and it is usually not a good one.
copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State head judge.
Any additions or corrections?
None from the defense, Your Honor.
None from the state judge.
What is the status of, did you go to Liberty County last week?
Yes, ma'am.
And what's the status of that case?
I had tickets and I have a court case that reset it to September 5th. So I'm waiting to go to court.
For the same offense that you're here on?
And they would have it actually before this office.
Right.
Judge, the state's recommendation in this case reflects certain impediments to us meeting our burden of proof and potential defenses that Mr. West may have. We're not conceding that we couldn't be a burden if put to it.
Thank you, Mr. Coleman.
That's why we made the offer.
And that's,
I appreciate that.
We talked about that, and make sure we reminded you that there was reasons why.
Perfect, thank you. All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 7 years. You're ordered to follow all of the rules and conditions of probation. And if you do that, this is a great opportunity because you don't have this conviction on your record. And if you complete the probation successfully, then at the end, this case is dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and facing a sentence of up to 10 years in prison. Do you understand? Obviously, you're a convicted felon. You understand you're not able to possess a firearm as part of Texas law. It is also a condition of your probation as well. And part of that is going to be for you to go get that other case taken care of as well.
Yes, me and him are talking about that other case.
Perfect. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over all your paperwork. All right, good luck to you.
Thanks, Judge.
Thank you. Mr. Rojas, you have Rebecca Rito, cause numbers 23 DCCR 0928 and 2106 and 2107. Ma'am, are you Rebecca Rito?
Yes, ma'am.
And Ms. Rebecca Rito, in each of your 3 cases, you're charged with a state jail felony offense of theft of property with prior theft convictions. What that means in each of those cases is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And I have in each of your cases here on the computer some plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 18 months in the state jail prison in each of those cases that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I want to make sure you understand what the possible consequences are and what your options are if you go to trial. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
And yes, sir.
Your Honor, I'm sorry to interrupt. I just want to point out that after today's rejection by the defendant, the state will be filing a motion to accumulate or stack these sentences in each of these 3 cases. Judge, I think they all have 3 different offense dates.
And does the offense dates make them or the conviction dates make them eligible for that?
My understanding is just so long as it doesn't come out of the same occurrence or transaction.
So what that means is there's the possibility, Ms. Rito, that the state will, sounds like the state will file, and then there would be the possibility, dependent on how I feel about any punishment, that would be left up to me, whether or not any possible punishments that you receive from a jury could be stacked on top of each other. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. And Mr. Rojas, you're appointed.
I am.
Ms. Rito, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Ma'am.
So, Mr. Rojas, you're released. Ms. Rito, we're going to appoint someone this morning. If you'll have a seat kind of on this side of the courtroom and watch for the clerk, she'll call you up and give you that information.
Yes, ma'am.
Thank you. While they're doing that, Mr. Bruce Smith on Pride Walker, cause number 24 DCCR 0784. It's a sentencing. There was an extra sheet that Kelly had on my desk. It was just a memo. Right, sir, you Pride Walker. And Mr. Walker was previously in court, entered a plea of guilty to...
Now hold on a second, because this next exchange is one of those classic courtroom moments where memory suddenly becomes very important. The judge is asking about the PSI. Basically, a pre-sentence investigation reported is a crucial step before sentencing because it gives the court background on the defendant. Missing that appointment is not just a scheduling mistake. It can make the court think the defendant is ignoring the process entirely.
The third-degree felony offense of indecency with a child by exposure. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir. And the addendums from statement, I believe, memorandum.
Yes. Are there any additions or corrections other than that?
No, Your Honor.
Any reason not to go forward with sentencing?
No, not the state.
All right, then I'm going to find, sir, that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Can I ask everybody, if you're talking about a case with the DA, that's fine. If not, I just got a lot going on and everybody kind of keep it down. Thanks. Okay, so defer all proceedings for a period of 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense and sent to prison for up to 10 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. And because it's a deferred, is there a requirement for registration?
Yes, sir. I believe Judge.
Did y'all already do that? Did y'all already fill out the registration admonishment? I don't know that I see it.
I don't remember, Judge.
I didn't see it on the tablet, Judge.
So if you'll do that before you, so you'll need to fill out another paperwork, and we talked about this on your plea. Because of the plea, you will be required to register as a sex offender. There's some information that you'll need to sign with Mr. Smith today that goes over that, and then have a seat and wait for probation to call you up, and she'll go over all your other paperwork. Okay? All right. If y'all will make sure and get that done.